Hello, I am Dr. Debashish Poddar from National University of Study and Research in Law, Ranchi. My module is Human Rights Treaty Bodies and Overview. Here, I shall introduce the definition, operation and characteristic features of treaty bodies working under the Office of the Human Rights Commission. Under the UN umbrella, human rights bodies are arranged in two areas. One is charter based bodies and another the treaty based bodies. These two areas of bodies are meant to serve diverse purpose to safeguard human rights. Here, I shall be deliberating on the second array of bodies, that is treaty bodies. To introduce the first array, the charter based bodies are driven by the United Nations Charter 1945 directly. Some of the bodies are Human Rights Council, Universal Periodic Review, Commission on Human Rights. At present 2006 onwards, it is replaced by the Human Rights Council, Special Procedures of the Human Rights Councils, Human Rights Council Complaint Procedure, etc. These are charter based bodies precisely because no other treaty is involved here. Though United Nations Charter itself is a treaty, but still charter being placed as in a special position of treaty, these are called charter based bodies, treaty bodies. These bodies are created by diverse treaties commonly called as international human rights treaties. International human rights treaties, these are centrally administered under the aegis of Office of the High Commissioner for Human Rights. In short, this is called OHCHR. These treaties are meant for diverse purposes, which we shall be deliberating. By and large, such treaty based bodies are meant to offer monitoring mechanism of implementation on the basis of given mandate provided by the treaty concerned. These treaty bodies take care of diverse issues related to human rights. Some of them are related to civil and political rights. Some of them are related to some other rights like economic, social, cultural rights. In these ways, these treaty bodies take care by and large almost all the issues related to first generation and second generation human rights. By terminology, treaty bodies refer to institutions created by respective treaties themselves for global governance of respective human rights regimes in the following areas: lawmaking for the given normative regimes under these respective treaties, monitoring implementation of human rights under these respective treaties, and adjudicating the gross violation of human rights under these respective treaties. So, in a nutshell, these treaty bodies at a time, they take care of lawmaking process, executing process and adjudicating process also. Though these are contradictory to the separation of power doctrines, but in this way treaty bodies work in a sense that these treaty bodies take care of legislative, administrative and adjudicatory process in different cloak. Sometimes it is the members of these treaty bodies sit in the cloak of legislator. Sometimes the members of these treaty bodies sit in the capacity of implementing mechanism, and sometimes they are sitting to judge the given situation in a country. Treaty bodies are diverse on the basis of the treaties concerns. These treaty bodies are human rights committees, Committee on Economic, Social and Cultural Rights, Committee on the Elimination of Racial Discrimination, Committee on the Elimination of Discrimination Against Women, Committee Against Torture, Subcommittee on Prevention of Torture, Committee on the Rights of the Child, Committee on Migrant Workers, Committee on the Rights of Persons with Disabilities, and last but not least, Committee on Enforced Disappearances. These committees has been introduced or came into force at different points of time depending on the adoption of treaty bodies mechanism by the respective state parties. International Covenant on Elimination of Racial Discrimination, it came into force on 21st December 1965, and the committee is Committee on Elimination of Racial Discrimination. ICCPR stands for International Covenant on Civil and Political Rights. It came into force on 16 December 1966. The name of the committee is Committee on Civil and Political Rights. International Covenant on Economic, Social and Cultural Rights, in brief ICESCR, it came into force on 16 December 1966. The name of the committee is Committee on Economic, Cultural and Social Rights. CEDAW stands for Convention on Elimination of All Forms of Discrimination Against Women. It came into force on 18 December 1979, and the name of the committee is Committee for Elimination of Discrimination Against Women. CAT stands for Convention Against Torture. It came into force on 10th December 1984. The name of the committee is Committee Against Torture. CRC stands for Convention for Rights of the Child. It came into force on 20th November 1989. The name of the committee is Committee for the Rights of the Child. ICMW stands for International Convention for Migrant Workers. It came into force on 18 December 1990. The name of the committee is Committee for Migrant Workers. CPED stands for Convention for Prevention Against Enforced Disappearance. It came into force on 20th December 2006, and the name of the committee is Committee Against Enforced Disappearance. In this way, several committees are working under several treaties, optional protocols, additional protocols, etc. Here in this graphical representation, it has been taken from OHCHR website, Office of the High Commissioner for Human Rights. The position of several committees are clearly stated. Under ICCPR, the relevant committee is working. Under ICESCR, the relevant committee is working. In this way, all these committees are working under which treaties and under which protocols, optional protocols, etc. These are graphically represented here. Committee composition is an important feature of this module. With little variation, by and large, composition of the committees may be mentioned thus: not more than one person of the same state is a cardinal provision for composition of the function. Another feature of composition of these committees are equitable geographical distribution of members and representation of different forms of civilization and of principal legal systems. Thus, committee should have the character of a global treaty body. These monitoring bodies run institutional system OHCHR introduced to safeguard the human rights. These monitoring bodies run by the institutional system of OHR introduced to safeguard the human rights. Committee functioning. Committee functions under several heads, as we have already discussed. Some of them are legislative, some of them are administrative, and some of them are adjudicatory in nature, but the committees are in no way replacing the courts or tribunals. So, in that way, committee has its own sui generis judicial mechanism, which we will come with the passage of time. Committee functioning may be divided in 5 parts: consideration of state party report, consideration of individual complaint, conduct of country inquiries, general comment, and meetings of chairpersons. So, first we will take care of considerations of state party report. Periodic reporting procedure is there in vogue. As part of periodic reporting procedure, state parties ought to submit periodic reports for state of affairs in the affairs of state to concerned treaty bodies for consideration, and treaty bodies possess jurisdiction of access to information from other sources as well, publish their observation about the status of concerned human rights accordingly. So, here rights and duties of the states and treaty bodies are demarcated clearly. State parties have duty to submit periodic reports for state of affairs in the affairs of state to concerned treaty bodies for consideration. This periodic report, so far as the duration is concerned, this may and does vary from state to state, but by and large this may vary from 2 year to 4 year. Whereas, treaty bodies have right to possess jurisdiction of access to information from other sources as well. Here the treaty bodies are entitled to gather information from civil society organizations, NGOs, or any other ways also. So, in that way treaty bodies possess elbow space to this end. Also, the treaty bodies has right to publish their observation about the status of concerned human rights accordingly, but this publication comes as a last resort when all other ways of controlling the human rights health of the nation state fails. Consideration of complaint. There is provision for complaint mechanism on the part of individual or other states about the state of affairs in the affairs of state in a particular member state of under a treaty. By definition, complaint is in the form of communication to treaty body from any other state party or parties, from individual or and group of individuals, information about gross violation of rights, commitments affirmed by the concerned state. So, in this way, in this format, complaint may be made to the treaty body. Report to complaint should be used as a last resort to international forum or treaty body. Resort to complaint is possible only after national remedies stand exhausted, and resort to complaint cannot be abused as appellate forum over and above national court or tribunal. By this mechanism, in international law, the sovereignty of state and the concern for human rights has been balanced in a systematic manner. Conduct of country inquiry. Country inquiry takes place on the part of treaty body on the basis of information about violation of concerned human rights. Despite commitment by state party to prevent the same and about the state of affairs in the affairs of the state. So, in a nutshell, country inquiry will take place under the auspices of the concerned treaty body and on the basis of any information received by the treaty body about gross violation of concerned human rights. So, sporadic instances of violation will not be taken care of by any treaty body. Also, the country inquiry will take place by the treaty body only in case of a state party fails to prevent the violation of human rights, and if the state of affairs in the affairs of state is reaching to alarming situation. Irrespective of its result, the decision of conduct inquiry itself seems matter of embarrassment for the state concerned. So, here the soft law jurisprudence comes into play, by which not penal provision, but the way international law is meant for civilized states, that is relied on by this mechanism. General comment is another feature of the functioning of treaty body. By general comment, we refer to a corpus of soft law for state parties, which constitutes by position of treaty body, developed by deliberation of members of the treaty bodies, issued by the body on concerned theme, and any theme falling within its jurisdiction. Thus, these comments may be either on thematic issue or on the method of work. Meeting of chairpersons, it is one of the most important function of the treaty body. Meeting of chairperson is an annual event of congregation. Meeting of chairperson is among respective heads of these treaty bodies inter se. Such a meeting is meant for offering space for dialogue across these bodies, exchange of news and views on diverse issues and challenges they face, sharing best practices on any given agenda, and strengthening for better efficiency along with coordination in time ahead. Sometimes it is seen that diverse treaty bodies are working in different direction. So, meeting of chairpersons help these treaty bodies to take care of coordination among them inter se. Regime strengthening process, it is a new invention on the part of Office of the High Commissioner for Human Rights, by which 2009 onwards a process got started to strengthen the treaty bodies by their coordination. In 2009, the Office of the High Commissioner for Human Rights circulated its call far and wide to submit consultation. This consultation was invited from the stakeholders, all stakeholders of human rights, and for better environment of treaty bodies regime. Accordingly, 19 pieces of consultation were received till 2012. In 68th session, UN General Assembly adopted a resolution to this end, which is markedly resembling the consultation papers received by the OHCHR so far. In conclusion, with the passage of time, all these treaty bodies evolve remarkable working method along with emerging themes, keeping pace with the growing need of time. In terms of their visibility, however, there is space for such bodies toward better performance in time ahead. Safeguard for human rights being essential insignia for good governance, breach of their rights commitments is bound to expose the states to vulnerability from threats of external aggression, internal regime change, etc., which we experience through Arab Spring. Decades back, the same experience took place in China also, when we have seen a sui generis spring in Tiananmen Square. Here lies some books, some other materials which constitute select bibliography to learn this subject in detailed manner. Thank you.